NACDL is the association of the nation's criminal defense bar.
Welcome back to another episode of Credits Without Contact. I'm your host, Laura Sheely, and co-host, The Child. Excited today. This one is kind of more about my co-host, a non-citizen of the U.S., than forensics. I know that we've done a lot of forensic stuff on the series, but today we're going to kind of go with a little bit more ethical type of a talk. I have two great guests today, Megan Ellman and David Bell. And David had spoken to me about this note that was written and how we'd like to talk about it. And I just thought, okay, I write notes all the time and nobody wants to talk about me having to take the cat litter out or the garbage out, but I understand that that's not the type of note. I have since been schooled, and it's a great note. And without much further ado, I would like to introduce my guest today on Credits Without Contact, and I'd like to thank you all for being here and being the champions that you are. Megan and David, please.
Hello.
Thank you for joining us.
Thank you for having us.
Yeah, thank you.
Well, let's start off before we get right into it. Let's start off a little bit. David, tell me a little bit about yourself. You are in the Kansas City, Kansas, Missouri area.
Yes, I've got the beautiful Kansas City skyline behind us.
Go Chiefs.
Go Chiefs! I do.
And Rock Chalk Jayhawks.
Rock Chalk Jayhawks and all the other. Yes, I'm excited to be part of a winning team. And so behind is a beautiful skyline. So I hope everyone enjoys it. I was a former public defender and in Jackson County, Missouri, so Kansas City, and did a bunch of those cases, and then left to the private world in 2007, and have been a private criminal defense attorney since then. So
outstanding.
Federal, state, and local criminal defense.
And Megan, tell us about yourself.
So my name's Megan Ellman. I'm from Buffalo, New York originally. So unfortunately, we don't win as frequently with our sports teams. But I graduated from law school in May and was admitted into the New York State Bar in January. And I practice immigration law, specifically removal defense and post-final order relief, and have, I'm very interested in kind of issues of the intersection of immigration law and criminal law and kind of the ethical requirements of criminal defense attorneys.
And you wrote in 2019, you wrote and published a note, which everybody that's viewing this will understand what that is. And so I think today we're going to talk about that note. How did you decide to do that, to write that?
So it was a long process. At GW, if you're on a journal, you have to write a note. And I knew I wanted to write something tied into immigration law because I knew I wanted to practice that. But I had the opportunity to do some internships at public defenders organizations in New York City as well as in DC. And it just really made me interested in kind of this, idea of, there being collateral consequences of conviction, and, the idea that there's this, large subset of people who have, really massive collateral consequences of conviction, but don't always know what could happen to them if they accept a plea deal. And so kind of through working with some professors and advisors, came to realize that, ethics might be a way to kind of navigate that and, make sure that non-citizen clients are getting the information that they need when they're entering the criminal legal system.
Well, and I think that your note was published in the George Washington Law Review. in 2019. And David, do we have that note that we're going to show our viewers on the screen?
I can get that up
Well,
and running.
why don't I do this? Why don't I let you guys talk about the note? I might chime in every now and then, but since this is been very interesting for me to read, it's kind of out of my purview. So I'm going to let the two professionals, and you guys are experts on that stuff. I will stick to DNA and crime scenes. And I'll just let you take over. You can do the share screen.
Okay.
Take over and just listen. I might pipe in every now and then, but otherwise, you two take over.
Wonderful. All right. Well, thank you for agreeing to do this, Megan, on short notice. I was excited. I was looking through for this topic because I do a lot of work with criminal defense that kind of is tangentially related to immigration and pretty much cleaning up mistakes by other criminal defense attorneys. And I came across this note, and I was just, floored by how wonderful it was to. I'm trying to click up on my computer. I'll figure it out in a sec. How great how much it tied into exactly what we're talking about. What is the title of the note?
So it's Unexpected Consequences, Why Criminal Defense Attorneys Have an Ethical Obligation to Inform Non-Citizen Clients of the Immigration Consequences of Conviction.
And maybe we'll pardon me, but we'll figure out a way of, if we can, either making it available by link or however we can to the audience. One of the things I want to talk to you about briefly is the difference between the law and ethics. And for everyone's definition, I'm just going to give you definitions to kind of lead our discussion. Talking about ethics as moral principles that govern a person's behavior or the conducting of an activity, and then the law, which is a system of rules which a particular country or community recognizes as regulating the actions of its members and which may be enforced by the imposition of penalties. I guess in this issue of criminal defense attorneys advising defendants that may face immigration consequences, is there a difference between the law and ethics?
So yes, I think that, well, the law has a very clear, well, I guess people could litigate it more. I would argue it should be broader, interpreted more broadly. But there are a series of cases that lay out the parameters of what advice criminal defense attorneys need to provide to their non-citizen clients on the collateral consequences of conviction relating to status and, basically what could cause a client to be entered into removal proceedings. I personally read the ABA model rules to impose a much higher ethical requirement.
And so what I'm hearing you say, and what makes sense to me is that, and we'll go through some of these cases, that the law, if you will, sets the floor or kind of the minimum standard of behavior for attorneys. The floor you can't go below, but at the same time that we can debate where the line is, the ethics set kind of the goal of where we want our behavior to be. Does that sound correct?
Yeah. It's, I think at its core, it's a spectrum between the law and, where people interpret the ethical requirements to kind of have them fall on that spectrum.
Okay, and we'll go through what that spectrum is as we talk today. I want to briefly talk about the different types of legal advice that we'll see in the cases. The first is just a misrepresentation of the immigration consequences. We'll talk about that. Hey, no worries, you won't be deported or removed if you plead guilty. The client relies on that misrepresentation and is then removed from the country. The second one is you never ask, or the client never asks, what are the immigration consequences, and the attorney never pipes up and says, hey, there might be an issue here. It's just silent. And then the third type of advice is, hey, I think there's an issue here. I don't know the answer. So we'll go through those. And when we talk about immigration consequences, which we'll go through in a bit, I also want to not leave out, there are an infinite number of consequences outside of the criminal justice system and the immigration system that can result from a conviction. And you go through some of those in your note, but just could you give us a few examples of kind of horrific consequences from a criminal conviction other than immigration consequences?
Absolutely. So, depending on the conviction, people might lose the right to vote. There might be civil commitment, civil forfeiture. You could be disqualified from public benefits, including public housing. People can lose their business and professional licenses. I mean, there's, a criminal conviction, even if it seems like the best option or was the result of a well thought out plea deal, can have really disastrous outcomes on a person's life.
And let's now go to the immigration side. Immigration is more than just, hey, is this person going to get removed from the country? But could you go through some of the immigration consequences that we may see from a criminal conviction?
Absolutely. So, I think you can really break it into two categories, right? So, first, a criminal conviction can result in somebody being entered into removal proceedings. So there are certain criminal convictions that form grounds of what are called grounds of inadmissibility and grounds of deportability that result in somebody entering into removal proceedings, which is the legal term for basically deportation, the process by which somebody could be deported. The second type is that it can actually bar people from forms of relief. So when you think of, immigration relief, a lot of people might be thinking of asylum. That's a really big one. A lot of criminal convictions can act as bars to individuals receiving asylum, withholding of removal, other forms of relief. And then related to that, it can also, certain convictions, even if somebody is fine while they remain in the United States, if they leave the United States and then need to apply for admission, basically, asking a Customs and Border Patrol officer for permission to re-enter the country, at that point, they could be entered into removal proceedings. And all of those are kind of, the first set, of which there's also, bars to naturalization or becoming a U.S. citizen and bars to becoming a lawful permanent resident or green card holder.
Oh, wow. So it's not just the ability to stay in the country or the ability to become a green card holder or lawful permanent resident or citizen, but also I heard you say that there could be situations where you do something today, nothing happens, like there's no lightning strike, but you leave the country to go maybe back home to visit, and you try to come back in and they run a record and all of a sudden they're like, no, you can't because of some past conviction.
Absolutely. And, it's not uncommon to have clients who have been in the country for decades, this might be the year that they're finally going to, leave the country and go on vacation. They have no idea that this conviction could cause that. And, 40 years in the United States, they try to come back and they're not allowed.
So let's talk a little bit about real life examples. And these are examples I've had in my practice. I've changed maybe change the gender, maybe change the crime, but these are based on real examples. And in fact, last week I had a client call me, and I had helped him out a few years ago on a federal white collar case and gotten him probation. And in fact, he had just finished paying his bill. And so I had done essentially the trifecta for criminal practice. The client was happy. I had gotten a great result and I had gotten paid. I mean, it doesn't happen like that. I thought about actually going out and buying a lottery ticket at that time. So he calls me up. The case is long over with, probation long over with. And he says, when was I convicted? And I'm like, oh, geez. Like, the only reason you're calling to ask about that is something wrong's happening. And I said, well, why are you asking? And he said, well, I'm applying for relief under the current SBA COVID crisis forms of relief. And he's entitled to a significant amount of money under that. But he said, if I was convicted in the last 5 years, I can't get those benefits. And of course, I went to look back and he was convicted in 16. So he did not qualify. But it seems to me, and we'll go through kind of how to define where you are on the spectrum, but it seems to me like that would almost have been unfair to me, Megan, to put a future unknown consequence that I couldn't even see. I mean, in 16, I wouldn't have been able to predict there was going to be a COVID crisis.
Well, I think that's really the big question. Certainly I think it's impossible to predict that, there would be a pandemic in 2020 and that this specific incidence of events would have happened to this client of yours or former client of yours.
Right.
I think in other situations, though, it really is so fact specific. It's having the conversations with your clients to figure out, what are their priorities and what could be affected.
That's good. And what we'll do is we'll circle back on each of these examples after the discussion to kind of see maybe what the answer is, to the extent there is an answer. A second person I had was from Asia, had come to the U.S. as a child. Brother had graduated high school here, went off to college. His older brother graduated, became a professional. The mother and father are highly educated professionals. The client was in his second year of college at a school nearby, was driving home during finals and came through a small town and was pulled over for expired tags or speeding, and had a remnants of a joint in his ashtray, which I think you're almost required to have that as a college student returning at the end of a semester. It seems like with some of my clients. But anyway, in his sock was an Adderall pill that he didn't have a prescription for. He was taking to study for finals, and I legitimately believe that. He was charged with a felony, and the attorney that had it at the time went ahead and pled him guilty. And he's now sitting back in Asia as a result of that guilty plea. Now, fortunately, we were able to go in to undo the guilty plea, and we're going to hopefully get him back. But what about a situation like that? I guess is that just an obvious one in your world, Megan?
Yes. So that one specifically, because it has to do with drugs, would be one of the, it's not just a question of what's ethically required. In that case, there would be a requirement for legal advice on that. I guess, if it was 2016 when the specific case happened, but yes.
So drugs bad. Is that in the immigration world, drugs bad?
Drugs,
right.
Anything relating to drugs, anything, it doesn't matter what kind it is, any type of drug that is not 30 grams or less of marijuana is really bad. All
right. And then also, just so we bring it up, also, I think, aren't sex crimes also within that category, or pretty much?
Yes, I think, yes.
Okay.
There's a little bit more analysis needed on that one.
Okay.
Yes.
All right. And then another case I had recently was actually a woman in 2017 is charged with a federal offense, and she had become a citizen in 2015. Okay. She is now pleading guilty, or being asked to plead guilty to conduct that arose or began prior to 2015. So she becomes a citizen in 2015. In 2017, she's charged, and the conduct that they want her to plead guilty to begins before 2015. Tell me, is there potential issues there that you would see right off the bat?
Yes. So, again, it's very situation and fact specific.
Sure.
But there are crimes within the Immigration and Nationality Act that are not based on the date of conviction, but instead based on the date of the commission of the facts underlying the criminal case. And so in that case, you need an immigration attorney, you need somebody who can kind of walk through what that analysis is and figure out if it's a deportable or inadmissible offense.
Go ahead.
And I was just going to say that, and specifically, under the Trump administration, there's now an office, I believe it's within the Department of Homeland Security. I could be wrong on that, but that is specifically, the goal of it is, to investigate old cases where non-citizens naturalized and became U.S. citizens and figure out if there are reasons why anyone needs to be denaturalized.
So, and I will tell you, and I've seen this before in these cases, when you apply, and I've seen the application, but I'm sure you obviously seen it more times than I have, but essentially the question on the citizenship application is, have you ever done something bad and never been charged with a crime for it? Yes. Right? Which, by the way, the answer for all of us is yes, right? Because we've all done something. I mean, even speeding. I'm sure we've all, by the way, this is attorney-client privilege between us, Megan, so we're fine. We can talk about it. But we've all done something bad. And so if you answer no on that, which you would probably have to answer, I would assume, to become a citizen, and then you're later convicted of a crime that's alleged to have occurred prior to you making that answer, then you've lied on the application.
Yeah, and I mean, and again, it's very fact specific.
Sure.
And specific, there's no way to kind of give a blanket yes or
sure.
no to that. But it points to the fact, it basically, yes, you need to have someone with immigration experience kind of working with that. Ideally, you would have had an immigration attorney consulting with the criminal defense attorney at the time to figure out, okay, does this client eventually, if he or she is a lawful permanent resident, does he or she want to naturalize in the future, and what effect could that have?
And then the final scenario, before we go into a little more detail, is I have a client who's not a citizen nor a lawful permanent resident. Client's not in removal proceedings, gets charged with a DUI. And this is the second DUI that the client has. and there's a videotape at the stop, and we're, it's obvious that not really going to have a defense. The offer is probation, but from what I understand, there's recent recent rulings that pleading guilty to a second DUI, while it may not have an immediate impact on this individual, could in fact have negative consequences to him in the future on his status. Does that sound accurate?
Yes, so it could affect some forms of immigration relief require good moral character, and it could affect whether somebody has good moral character for purposes of naturalization or cancellation of removal, and it could also affect a judge's discretion. So pretty much, the majority of immigration relief is discretionary. So even if someone is statutorily eligible, you have to prove to a judge why you deserve it. Why should this judge in his discretion grant you asylum? And a DUI could certainly be a factor in a judge's discretionary determination.
So let's talk about that. Let's talk about a kind of a very brief immigration law for non-immigration attorneys. When you talk about removal proceedings, like, how does that start? What is that? Because I think ultimately that's what we're going to talk about. That's where we're going to see the collateral consequences from our conversation today. So if you could just briefly walk us through what that is, what that means, and what happens there.
Absolutely. So I am, for purposes of describing this, going to focus on non-citizens who have some form of criminal conviction or interaction with the criminal legal system. But I think it's important to kind of note that removal proceedings can also happen for other reasons. But so basically, you have someone is arrested or convicted or charged, and somehow Immigration and Customs Enforcement, ICE, learns. ICE might learn about that through what's called a 287G agreement, which is an agreement with a local law enforcement agency where ICE basically delegates immigration enforcement power to that local agency. And then that agency will contact ICE if they have a non-citizen in custody. ICE, even if there's not a 287G agreement in a jail, ICE is also present in a lot of jails, so they might just be there and learn. There's also ways where individuals can contact or report people to ICE or to the government through what's called the Victims of Immigration Crime Enforcement Office, which is also new under the Trump administration. And then finally, there's sharing of fingerprints between law enforcement and ICE, and there are also community arrests, which many people might have read about or be reading about in the news. ICE arresting people at courthouses or hospitals or churches or work, and when they're arrested, they learn that someone has a criminal conviction. And so
yeah, go ahead.
I was going to say, from there, once ICE kind of, they learn that Megan Ellman is, a non-citizen, that, they learn that somebody is a non-citizen and that person has a criminal charge or conviction. They can either at that point arrest and detain that person, or they might just serve that person with what's called a notice to appear. To clarify, even if that person is arrested and detained, they're also going to be served with the notice to appear. The notice to appear is basically the charging document. It starts removal proceedings when ICE serves that on both the non-citizen and on the Executive Office for Immigration Review, which is the Department of Justice office that houses immigration court.
And so then we go before a court, and as I understand it, it's not a there's three branches of government. There's the executive branch, the police, essentially, or president, the police, law enforcement. There's the Congress, the legislative branch, and there's the judicial system. But this is not in the judicial system, this court. Is that right?
No, it's not. So the immigration courts are within a unit of the Department of Justice, and the what we call the trial attorneys, basically the prosecutors in removal defense cases, are attorneys that are employees of Immigration and Customs Enforcement. They are part of the Department of Homeland Security.
All right. And so when you talk about, so someone's charged, if you will, they get a notice to appear, and they're going to show up, and then what? You ask for some type of relief? Is that, what does that mean? Like, please don't do this. Don't kick me out of the country. What does seeking relief mean?
So similar to a criminal case where you, at the start of the proceeding, the defendant has the opportunity to have the charges read against that are being filed against him read to him. In immigration court, you will show up to what's called a master calendar hearing, which is it's a preliminary proceeding. And that non-citizen is being informed of the charges of removability that are against him or her. And so some of those charges might be kind of within this group of charges that are called charges of inadmissibility, and some of them are charges of deportability, which is kind of getting into the more intricacies of immigration law. But basically, it's this two-part system where DHS has to prove that someone is removable. They have to prove those charges. And then once removability is proven, the burden shifts to the non-citizen, who then has to show that he or she is eligible for some form of relief.
I see. And this is that where we're going to see the criminal conviction kind of arise, that you have to overcome this criminal conviction, or is it the criminal conviction that could actually, it puts you in the position of being deportable or removable, and then it also prevents you from overcoming the burden that is shifted? Is that what I'm hearing?
Exactly. So there's, depending on whether someone, basically a criminal conviction can form the basis for someone being entered into removal proceedings. And it's, kind of a complicated legal analysis as to whether a criminal conviction is a ground of removability. But then if that is established, for example, if someone is caught with cocaine and has a conviction for possession of cocaine, that's very clearly a ground of removability that might be established. And then from there, that conviction for possession of cocaine could also potentially bar someone from receiving, let's say, asylum.
I see. And I guess it sounds like there's a lot of stuff going on in immigration court. You get a charging document, you get to defend yourself. So why, as a criminal defense attorney, why don't you just let me be and let me deal with my criminal defense part of it? And then if immigration hears about it, then Megan, you take care of it.
So there's actually no right to counsel in immigration court. So
that's insanity. What do you mean?
So yeah, there's no. I have a note somewhere that I'm looking for. It's basically the statute says something along the lines of. The non-citizen has the privilege of being represented at no expense to the government by counsel of the non-citizen's choosing. So basically, if you're in removal proceedings, you can have an attorney as long as you can find an attorney and as long as you can pay for it yourself. And if you can't, then you're on your own.
So I guess what's so amazing to me, and I've been doing this for a while, and every time I wade into the immigration area just to do a talk like this, I always have to relearn it. It is horrifically complicated to the point of, I used to do tax law 20 years ago. It makes tax law look like speeding tickets. And so it doesn't there's no way that you would ever be able to understand this as a layperson.
It's incredibly difficult. And there's, a variety, in my personal opinion, a variety of problems with it. If you have someone who's unrepresented, then the judge is in this position of kind of adjudicator lawyer, where
Right.
the judge is really the only person who would theoretically be explaining what's going on to, the individual removal proceedings. But yeah, so you have a lot of, there's actually really a dearth of immigration attorneys, and so many people go through proceedings without representation.
And so it seems to me then the goal would be, and I know you and I have talked about this before, to keep people out of immigration court.
Exactly.
And that's why we're here today, to hopefully talk about ways of doing that. So let's talk. And by the way, one other thing I wanted to mention, I think on the drug charges, not only are you almost guaranteed to be removed, but don't they hold you in detention without the possibility of bond many times on drug cases? Is that a mandatory detention?
So I don't know offhand if it's a mandatory detention,
Mm-hmm.
but I wouldn't be surprised if it were, and that there are many types of convictions for which there is automatic
Mandatory.
mandatory detention, and there's actually very limited opportunity for review of that,
Oh, wow.
determination as
By,
well.
by the way, before we leave this, and we'll go on to right to counsel in the criminal cases and what responsibilities are on our end. We keep throwing around the word conviction. Now, in Missouri, there's two types of dispositions. One's called an SIS, suspended imposition of sentence. If you walk down that probation, you're not deemed to be convicted under state law. There's a suspended execution of sentence where the sentence is given and then the sentence is suspended. But at that moment, under Missouri law, you are deemed convicted. But under federal law, I guess they don't. I'm telling you from what I understand, and I'm not asking you to opine on Missouri. They don't care what you call it. They're calling it a conviction. Is that generally the case? You've seen that, and then does it apply to situations that I wouldn't even think of as convictions?
Absolutely. So under the Immigration and Nationality Act, there's a really broad definition of conviction. So, there's certainly the, quote unquote, formal adjudication of guilt that we might think of. But there's also, any withheld adjudication of guilt is still a conviction if there's, if there's even like sufficient facts to find that person guilty and some form of punishment or penalty. There's basically all of these definitions of conviction that make it really hard for the kind of alternative outcomes that, I think a lot of criminal defense attorneys would consider to be wins in their cases. A lot of those still are convictions for purposes of immigration law.
So one of the things that brings up is the win for me, other than a dismissal, is what I'll call a delayed dismissal, which another term for that is a diversion, where you stand up, maybe you admit in open court or on a piece of paper what you did that makes you guilty, and the prosecutor says, you know what, if you follow these rules for the next year, I'm going to dismiss the case, but you need to jump through these hoops. Maybe you need to go to treatment. You need to stay out of trouble, whatever it is. It sounds to me like in that case, that could very well be considered a conviction for immigration purposes, even though we all know it's going to be dismissed at the end.
It's very likely that could be.
Wow.
And when they talk about, for example, that the sentence, basically like any form of punishment, penalty, or restraint on liberty, there's an immigration case that has found that even just court costs with adjudication of guilt is enough.
Wow.
So we're thinking about like a sentence that might qualify someone, make something qualify as a conviction. It's not just sentences as we traditionally think of it. It's, court costs, fines, penalties, anything.
All right, so let's move on then as we get into what the criminal defense attorney's obligations are, and let's go back very briefly. But I always like to go kind of back to some beginning. Well, I guess you have to start somewhere, and that's Gideon v. Wainwright, 1963. There was a guy that appeared without counsel in a breaking and entering case in Florida. He requested counsel. The Florida only permitted appointment in capital cases. He was sentenced to 5 years, and the question was. The Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. In general, what happened in that case?
You have the right to counsel, even if you can't afford one.
And so I'm reading a quote here from there. It says, the right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. But I guess at that moment, and I'm not trying to get into the weeds of Gideon, but I read that and I'm like, all right, well, does that mean I get the Johnny Cochran version of lawyer, or do I get the estate planning attorney that's going to take some money to handle a criminal case lawyer for the first time? It seems kind of unclear there as to what that standard is.
Exactly, and so that kind of leads us into Strickland, where it's not just the right to counsel, you have the right to effective assistance of counsel.
And in that case, I saw that Strickland is a Florida case in 1984 is a death penalty. The defendant pled guilty, had no significant priors or criminal record, and he was under extreme stress at the time that the crime was committed. The trial judge even said, quote, a great deal of respect for people who are willing to step forward and admit their responsibility. And in preparing for sentencing, the defense counsel spoke with respondent about his background, but didn't seek out any character witnesses, didn't do anything to get psychiatric assistance. I think spoke to the family by phone, and the court said, no, you do have some expectation. I think they used the term reasonably effective assistance of counsel. And how do I, looking at that case, how would I know what that means?
So Strickland essentially sets out a two-part test for what it means to provide effective assistance. So you have part one, if a defendant is raising a ineffective assistance of counsel claim, they have to show that the counsel's performance was deficient, which means it fell below an objective standard of reasonableness. And basically what that means is that you have a court that's looking to the standards of the legal profession. They're looking at ethical duties, prevailing norms. What does the average attorney do? And that's kind of the standard that courts are going to hold attorneys to. It's, what is the average person in this practice who's complying with the ethical requirements doing? But this first part is very deferential. So there's a presumption that counsel rendered adequate assistance. And so once you move from that step to part two, the defendant has to show that that the deficient performance actually, prejudiced him. So that but for counsel's errors, the result of the proceeding would have been different.
Wow. I think, it's interesting because I've handled some of these and it's always like, well, we wouldn't be here if we weren't prejudiced, right? He's the guy sitting in prison. He's got a conviction, whatever it was. But I think going back to the first prong, falling below an objective standard, I thought, didn't the court actually cite to various ethical standards in coming up with that conclusion?
Yes. So they cite to the ABA's model rules in that case.
And we'll talk about that in a bit, but I did notice in the opinion it said, indeed, the existence of detailed guidelines for representation could distract counsel from the overriding mission of vigorous advocacy of the defendant's cause. Moreover, the purpose of the effective assistance guarantee of the Sixth Amendment is not to improve the quality of legal representation, although it is a goal of considerable importance to the legal system. The purpose is simply to ensure that the criminal defendant receives a fair trial. I mean, I guess the impression I get here, and then we'll move on a little bit, is that they're looking to say, all right, was he treated fairly? Did the system produce a fair result based upon all the players participating, not whether the defendant received the best possible defense? Is that right?
Exactly. It sets kind of a low bar.
And they use the term reasonably effective counsel or reasonably effective assistance. And, I was thinking, you and I were talking, and if I had to go to a doctor, a heart doctor, and I doubt I would ever go in and say, doc, I'm just looking for reasonably effective assistance here. It almost seems ridiculous, but yet the same consequences presumably could arise in criminal cases that would arise in a going to a heart doctor.
Yeah.
What's the next? The next one we have is Hill v. Lockhart. Just generally, you have a quick summary of that. Not even a summary, just a quick holding in that.
I'll let you handle that one.
Okay, all right. So I thought Hill v. Lockhart would permitted us to do that. If the Strickland applies to guilty pleas, or Strickland applies to the plea part of the plea process. And the other thing about it, which I know we always focus on trial, but the reality in the criminal world is that 90%, I don't know the exact percentage, it seems to change, but it's a humongous percentage, resolve themselves by agreement and not by trial. And then we have, I know, Missouri v. Fry, which was the defense counsel has the duty to communicate formal offers from the prosecution to accept a plea on terms and conditions that may be favorable to the accused. And then Loeffler v. Cooper, which was a defendant was prejudiced by counsel's deficient performance in advising petitioner to reject the plea offer and go to trial. And so that's kind of where we're at on the overall ineffective assistance of counsel. But now I'd like to go to kind of back to our immigration area, and that starts off with, I think, one of the foundational cases is Padilla. Would that sound right?
Exactly. So Padilla came out in I believe it was 2010. And it came out kind of in the midst of this national conversation about collateral consequences of conviction, and what which of those consequences do criminal defense attorneys need to warn their clients about, essentially? And so, turning to the facts of Padilla, you have a man who has been in the United States as a lawful permanent resident. He's been in the U.S. for over 40 years. He lives in California, is a licensed commercial truck driver. He served in the Vietnam War, has a family, and essentially he's driving and was pulled over, and he's then arrested for possession of marijuana. And so throughout this the ensuing criminal process, Padilla is asking his attorney, what effect would this case have on his ability to stay in the United States? And during those conversations, his attorney repeatedly told him, don't worry about it. It's not going to have any effect. They can't deport you because you've been in the United States for so long. Fast forward, his criminal defense attorney was unfortunately incorrect. And as we talked about earlier, drugs and immigration law are very bad. Right. And that was a deportable offense. And so what came out of, this really, kind of stressful and really terrible set of facts, like how stressful that must have been for Padilla and his family, is that the Supreme Court, made a statement in this case that they held that attorneys have the duty to give correct advice on immigration, or basically to give correct advice on immigration consequences when the deportation consequence is truly clear. And so they cabined it to be, you're focusing on deportation as the consequence and the situations in which deportation is truly clear. Outside of that, they have a more limited obligation to just say it could have immigration consequences, but not much beyond that.
But I looked, in reading Padilla again, and every time I read it, I learn something new in there. In reading Padilla again, it was, the way the court made it sound was like, well, you just look under this INS statute, and it's like clear as day. Like there'd be like a sentence that says, Padilla, you will be deported if you plead to this. Like it's just that clear. But when you look at the statute, it's anything but clear. So I guess I'm having trouble understanding it. In your world, Megan, there is nothing clear. I'm just telling you, from an outsider looking in, there's nothing clear in immigration. So I don't know what does that even mean then, as you read Padilla.
So that's the point. I personally would like to read Padilla to be all encompassing and to say that it is very clear and that people, attorneys should, research and figure it out. But I think unfortunately, based on some of the light research I've done on the application of Padilla across the country, it really has been kind of cabined to that language of truly clear. So situations where, as was the case for Padilla, you can open up the Immigration and Nationality Act and understand pretty quickly and pretty clearly that, this marijuana drug offense was a deportable offense. But the Supreme Court in the case, really, they make a lot of the fact that this specific conviction was, it was easier to understand that was a deportable offense. And they kind of separate that out from, the vast world of unclear deportable offenses.
But it seems like in this, and we'll get into this as we go into the ABA model rules in a little bit, but it seems to me that that almost anything I do on the criminal side for somebody who is not a citizen, and even if they are a citizen, if they were naturalized, I still could have an impact. It seems like anything I do either has an impact or could have an impact.
Yes.
And so that would seem to me, at least from that reading of Padilla, that you have an obligation to determine what that impact is.
So I believe so. I think Padilla, unfortunately, in its application is more limited than that. I think it has been limited to, in practice, limited to, you need to identify if there could be an immigration consequence. You need to warn that there could be an immigration consequence. And if it's really obvious that the consequence will be deportation, and that's that very clear circumstance, you have to tell the client.
But I want to break it up into this in two parts. The first thing is, in this particular case, Padilla was actually given bad advice. He was told incorrectly. The client relied on that advice to his detriment, and he was deported or removed from the country. I guess, what do we say about the situation where I just as the attorney remain quiet? Like, you know what, his last name's Padilla, maybe I should look into it. Maybe he mentioned he was born somewhere else. You know what, he's not asking, I'm not telling. What about an obligation in that situation, in a situation where it's clear what the immigration consequences are? Is Padilla saying, I still have an affirmative obligation to come forward and say something?
Yes. The Supreme Court basically discusses, that very question of, affirmative misadvice versus just misadvice through silence. And they say that it's, basically it would be silly to have that distinction, because it would just invite attorneys, or basically attorneys would be encouraged in that case to give no advice at all, even if they know.
They'd be encouraged to remain silent.
Exactly.
It seems. The other thing that's brought up in this case is, and this goes back to some of the examples that we'll finish with after we go through the ABA model rules, but is the idea of, hold on, let me stop for a sec. It's the idea of what consequences you have to warn them about, because immigration, when you plead guilty, I think people have to have a knowing, voluntary, intelligent waiver of their rights. They got to know what they're doing and know what they're giving up, and to a certain extent know what's going to happen. They may never not know the sentence because it's up to the judge, but they know as much as they can about the system. But certainly I can't predict every possible consequence, nor can I be responsible for every possible consequence that results here from a plea. Has the court kind of taken immigration and put it in its own special category? It's not necessarily a direct consequence. It's not a collateral consequence. It's a special consequence.
Yeah, so the court focuses on deportation specifically. They kind of sidestep the issue of all of those other collateral consequences that could arise, both within the immigration realm and without. And they focus on deportation because it is such a severe consequence. The idea that when somebody is deported, they can't read, they're being separated from families and communities, from work. They, often have, there's a 10-year bar that prohibits them from reentering. Deportation really as something severe and unique in its severity. At least that's how kind of the Supreme Court captains it.
And so they've, and I see, and in reading it, it does appear they've kind of tried to limit it to immigration, particularly deportation, as its own special thing. Exactly. And so what we've got if in situations where it's clear, immigration consequences are clear, although I still don't, although that's not clear to me, attorneys have the affirmative obligation to give the right answer about those clear consequences.
Yes.
That sounds right. So
clear deportation.
Clear deportation. So I guess my question is, you can't expect me to learn immigration law. I mean, I guess I can learn a little bit, and I have, but not enough to where I feel like I could advise someone. Maybe now I know possession of marijuana over 30 grams. You just know, but it seems horrifically complicated. So just based on Padilla, what am I supposed to do?
So, I mean, just based solely on Padilla, the legal obligation is that, you either research it yourself and, you figure it out as an attorney and do your legal research, or you consult with an immigration attorney.
I see. All right. Well, let's move on. By the way, I wanted to point out the Scalia and Thomas's dissent in Padilla, where they said, in the best of all possible worlds, criminal defendants contemplating a guilty plea ought to be advised of all serious collateral consequences of conviction, and surely ought not to be misadvised. The Constitution, however, is not an all-purpose tool for judicial construction of a perfect world, and we ignore its text in order to make it that. We often find ourselves swinging a sledgehammer where a tack hammer is needed. The Sixth Amendment, as originally understood and ratified, meant only that a defendant had a right to employ counsel or to use volunteered services of a counsel. So that's from Scalia and Thomas, and it sounds, in fact, like that's what's going on in immigration court right now. Like, that's what's in effect right there, and it's only some tiny percentage of individuals there actually have counsel.
Exactly, which is, an unfortunate circumstance.
So then the next real quick, the next case is it Chaidez? How do you pronounce that?
I say Chaidez.
Chaidez. And so there's always like 2 steps forward, 1 step back, right? So Padilla comes out, you're like, oh yeah, we win one, and then this case comes out, and it just, without necessarily going to the facts, what do we learn from Chaidez?
So basically, Chaidez says, that Padilla is not a new rule, and so it's not retroactive. And it also, there's a lot of dicta in there that indicates that the court is kind of, really cabining Padilla to its language. So they say, they talk a lot about deportation. We say it is unique. It is a particularly severe penalty and one intimately related to the criminal process. Indeed, immigration status makes it nearly an automatic result of some convictions. And then the court talks about how, they view this wall that's between direct consequences that criminal defense attorneys have to warn of and collateral consequences where there's this open question. And they view this wall between it where where kind of Padilla is a single chink in an otherwise, spotless wall that separates the two and separates the obligations.
And so I've had this come up before. I had and so then what happens in these cases is that you only need to look at this stuff based on the administration that's in. And so if someone starts ramping up these deportation efforts, then all of a sudden the conviction from 2002, I had somebody who had a cocaine conviction from 2002, which is before Padilla. All of a sudden that matters, right? Because they're starting to impact that. And actually, I think you mentioned in your note that under the current administration, they've kind of revved up who they're looking to remove. Is that right?
Exactly. So, President Obama deported a lot of people, but he tried to kind of cabinet or provide some forms of enforcement guidelines. So he was interested in focusing on individuals who had criminal history or gang, members of gangs, those convicted of felonies or aggravated felonies. He in his enforcement guidelines was not looking as much at entering people who with, misdemeanor convictions into removal proceedings. But in 2017, there, right after President Trump's inauguration, he released a executive order. And so now the new removal priorities include any non-citizen who has committed a crime, has been charged with a crime, or has done anything that may constitute a chargeable offense. And so it's really broad. It could encompass, the administration is not just looking at convictions, they're looking at any action a person has taken that could be a conviction or could be a charge.
And so we're just leaving it to the motivation of the ICE enforcement to basically whoever they want to pick up, they have it's almost limitless now as long as someone falls in the categories that you just read.
Exactly.
The final case, just real quickly, and then I want to get to the ABA model rules, was Lee. And I think in Lee, the issue was he pled guilty based upon misadvice from an attorney in a federal drug case. And I can tell you, having represented people in federal court, that if you're being charged with a drug offense in federal court, they've got your client, at least in my cases, they've got him on a wiretap 25 different ways to Sunday talking about drugs. They've got 30 million people testifying in order to get a 5K to get credit. You are screwed. You generally, there may be an exception, you're screwed. And so it was interesting in the Lee case, the court said, well, yeah, it was misadvice, but there's no prejudice because if he went to trial, he was going to lose anyway. And so the court holds what in that situation?
Well, so in Lee, they actually look at specifically the decision to go to trial, and they basically say that in this case, the prejudice came in the fact that he went to trial, and that, basically this idea of like certain deportation is very different from almost certain deportation. So
it was worth the risk because he was going to be deported by pleading. If we had just a little bit extra chance of staying and that was important, then it was worth that.
Exactly.
That's right.
The idea that, at trial, even if it's the government, even if they're wiretapping you, you never exactly know what's going to happen. And so it might be, might be probable that it could lead to deportation, but it's not 100%. And so that's a very, that even if it's kind of 0.1% that could make the difference, that 0.1% matters in the decision of whether to take a plea or go to trial.
And the one thing, and I appreciated that opinion, because what it said was that we're really going to look to the individual defendant and say what was important to that individual defendant. And in every case where I've had an individual who's a non-citizen, that is the most important thing, right? Otherwise, they wouldn't have come to my office usually. I mean, they would have left already if them staying wasn't important. So let's move on then now to the ABA model rules. And I know we've talked about the Supreme Court has referenced these rules. You talk about them at length in your note. The ABA model rules are what? Why do I have to follow them? How do they affect me as a Kansas and Missouri lawyer?
So they are non-binding rules that lay out kind of the standard ethical obligations of attorneys. They're basically setting out rules for attorneys, like ethical rules for attorneys' conduct. They're non-binding. They are not, if you violate an ABA model rule, it's not a cause of action. You're not going to be disbarred, but they're important because 49 of 50 states have adopted their own state ethical rules that are based on these ABA model rules. And when you're looking at state ethical rules, all of a sudden those are binding on an attorney. So, if I violate a New York State ethical rule, I could be reported to a grievance committee.
I see. And so the rules we're going to talk about are, it's not necessarily a cause of action, someone suing me based on these, but I could be reported to the bar and potentially lose my license for violating one of these.
Exactly.
And so, go ahead.
We talk about the model rules, even though they're non-binding, because so many states have adopted them that they're it's a good way to talk about legal ethics on a national level.
So Rule 1.1 is competence. And I guess, Meg, when I first saw this, I'm like, well, you mean all I have to do is be competent? I mean, that sounds almost absurd to have to put that into a rule. Like the next one's I have to wear clothes to court. I mean, tell me what is competence? What does that mean?
So competence is knowledge, skill, thoroughness, and preparation. And basically what it means is that an attorney needs to have the necessary knowledge in the field of law to represent a client. And if she doesn't have that knowledge, she needs to research and study until she finds it. So it's basically the idea of, as an attorney, you need to know what you know and also know what you don't know. And if you don't know it, you need to be able to do the research to find the answer.
Yeah, but I hold myself out as a criminal defense attorney, Megan. I didn't hold myself out to you as an immigration lawyer. So are you saying I now have to go learn immigration law as a result of this competence rule?
You don't necessarily need to go and learn immigration law, but you need to figure out what aspects, what about immigration law do you need to know in order to correctly advise your client or, allow your client to make an informed decision.
All right, then 1.2 is scope of representation and allocation between client and lawyer. What is that?
So Rule 1.2, scope of representation, it basically breaks up the attorney-client relationship into objectives and means. And so a lawyer needs to I need to work with my clients to figure out what are their objections or their objectives of this representation. And then as an attorney, I should still consult them, but I'm in charge of the means of achieving those objectives.
And it seems like in the clients I've worked with, the non-citizen clients, one of the objectives is always to stay in the country.
Exactly. And so I think, in my read on that, when I'm reading this model rule and I'm thinking about the context of criminal defense attorneys representing non-citizen clients, I'm thinking about, as an attorney, you cannot assume that the objective is a shorter sentence or innocence or something relating to kind of the ultimate penalty. Instead, you need to kind of talk with that client and figure out if maybe staying in the United States or maybe being able to naturalize, maybe that's the end goal.
And it's interesting because it seems to me that the objective that you may be hired, the criminal case is the entree into that person's life, but the objective you're hired for may have to take place outside of the criminal realm, like you're talking about here.
It's essentially, in setting that objective, it's not saying that, you as a criminal defense attorney need to be the attorney walking your client through the naturalization process.
Mhm.
It's instead figuring out, okay, if the most important goal to my client is that at the end of this criminal case, she still be able to naturalize, what outcome do I need? What outcome does she need at the end of this so that there's not a criminal bar to her naturalizing, so that there's not, for example, good moral character is a requirement to make sure that at the end of this case, she still has good moral character for purposes of her naturalization application.
And then 1.3 is diligence, requires an attorney diligently advocate for a client's interest despite opposition or inconvenience. And I was thinking inconvenience when I looked up that the the possession immigration rule. I was like, God, this is going to be horrific. Like that, I guess I don't know if this is like David, you need to do a little bit more work here. Is that what diligence means, or what are we getting at here?
I mean, I think it's fact specific, but it's basically saying, you've identified that this is the objective, and you've identified that this is the realm that we're talking about, and that there could be an immigration consequence. And so you need, basically figuring out like what could that consequence be, and that could be you doing the research, but it could also be, consulting with an immigration attorney. It could be, taking advantage of the resources that organizations like the American Immigration Lawyers Association distribute, that kind of discuss the criminal or the immigration consequences of conviction. Kind of doing your research, basically.
And then communication, the 1.4, requires an attorney to communicate with their client, understands the client's interests, and to jointly decide how to achieve those interests. I mean, that almost seems like an obvious one. You need to speak to your client. I mean, and figure out what's motivating them and what they want.
Exactly. And there's actually been an amendment to that model rule that requires attorneys not just to communicate, but to stay in, continual communication with clients, so that it's not just one phone call at the start of representation and one phone call at the end, but that you're staying in touch as the process evolves.
And then the next part that I want to go over, and then I want to go back to these examples, is this. You mentioned in your note the ABA criminal justice standards for defense attorneys. What is that, and how is that compared to the rules we just talked about?
So this is also a set of standards that's created by the American Bar Association. They are similarly non-binding. Fewer, to my knowledge, fewer states have adopted them. But this is basically, you can think of this as the ABA writing out its gold standards for criminal defense attorneys. Saying, in an ideal world with every attorney, living up to the kind of highest level of his or her ethical obligations, this is what that attorney would be doing. And so they talk about, very specifically, seeking out supervisory advice, going to immigration attorneys. They talk about, not just thinking about collateral consequences of conviction, but thinking about the collateral consequences of decisions and actions. So at every step, how could this affect a client, in the immigration case, but also in other civil areas?
But it seems to me though, Megan, that we just went over 4 rules that seem to, cover that, right? If I sit down and say, Megan, tell me why you've come here. What is it you want? Okay, you've identified what's most important to you, and now I've got to get up off my rear end and go do it. So it seems like it's already there. What's extra? Why do we need something more?
So personally, that is my read on the ethical rules. My read on them is that they do require attorneys to do all of this. They require attorneys to seek out immigration advice or to do research and to, do everything that the criminal justice standards require. But it's not explicit. And it's not legally required. We just talked about Padilla and the legal requirements, and that's a much lower floor. And so what the criminal justice standards do is really explicitly lay out what are those golden standards, where in a way that there's less room for interpretation than there is in the much broader model rules themselves. So for example, one of the criminal justice standards says explicitly, determine a client's citizenship and immigration status, assuring the client that such information is important for effective legal representation, and that this information should be protected by attorney-client privilege.
Well, it's interesting that it would almost suggest by, I guess the other way of looking at it would almost, the argument would be that by separating it out into these standards, that it's not included in the first 4 rules, right? Otherwise you wouldn't need it, which doesn't make sense to me, because when I read the first 4 like you, I'm like, well, I don't understand. I need to hear what they have to say, set forth what their objectives are, and go do it. Or I guess tell them explicitly, I can't do this, or I'm not going to do this. So let's go back then real quick to our real world examples and kind of go through that based on some of the rules and what we've talked about here. And then I know we may have a few questions after that. The first one is the client that called me last week and said, hey, when was my conviction? I'm about to qualify for SBA. You did a great job, David. Thank you so much. When was I convicted? I say 2016. He's like, oh geez, I can't. Surely I don't see anything under Strickland that binds me here. Would you disagree with that?
No,
Okay.
I don't.
And ethically though, what about ethically? I guess it seems to me almost ethically it would be something like when he was pleading, and hopefully I did say this, is listen, there may be a myriad of other consequences that I can't. What do you think about that? I mean, is almost, do I have to make that statement, do you think? Is it advisable to make that statement? What's your thought of?
Is that it would be, making a statement, broadly similar to, what judges have to talk about in their colloquies, that this could have effects. I think whether you'd have to warn him specifically of, you may be ineligible to get a loan for 5 years would probably depend on the specific facts. Has he told you about this business? Was he in financial risk then? Was this something that you both discussed as, basically, did you have was it a priority of his when he was?
That's a good point. Well, and what's a good point about that is it again, it goes back to sitting down and talking to the client, because if the client never brought this up, then surely, and I never knew COVID was going to happen. I didn't know there'd be an SBA program. There'd be no way for me to warn. Let's go to the next one. The individual from that's now already been deported, who was caught coming back from school with an Adderall in his sock. It seems to me like had I had that case originally under Padilla, Strickland kind of Padilla, the answer is what there?
So remind me.
Sure. This is the one that has that was caught with a joint in the car and then had a felony possession of a controlled substance charge.
So in this one, even, the legal floor, you would have to advise that, and I think this is very similar to the circumstance in Padilla, where it's not just of possible immigration consequences, but advise of the deportation consequence.
Right, and so that's where we have the legal floor, if you will, and the ethical mandate. Those kind of are the same at that point. Under both, you need to report. Then the other one was this kind of middle ground. This is where the client has applied for citizenship, received it in 2015. In 2017 is charged with a crime and is now being asked to plead to a factual basis that goes back prior to the 2015 application. So basically, when the client pleads guilty, he very well may be in a situation where he's deemed to have lied on his application when he said in 2015, I've never done anything wrong for which I've not been charged with, right? And so he's now about to plead guilty in 17 to a factual basis that may say in 14, yeah, I did do something wrong. So I guess I'm trying to understand what do I do in this situation? I mean, I can't, is it clear consequence?
So in this case, it depends again on what the criminal conduct is. So I think that the specifics of the criminal conduct in question will need to be assessed, because that may influence whether it's a clear consequence or not. But I think at its outset, I'd say that there is the requirement to, at minimum, advise of possible immigration consequences, even if it's not clear. And on my read of the ethical rules, there is the additional obligation to consult with an immigration attorney and to or do your own research or advise the free resources online. And figure out what could happen as a result of this. Right,
and I appreciate you and I are just engaging in kind of a conversation based on these principles. And I think in this particular case, I have reached out to an immigration attorney and had from the very beginning, but it seems to me that, and I'm just trying to understand the requirement in a situation where there are consequences in the immigration world, but those are not clear-cut consequences, right? It's almost to the point where I come to you, Megan, and you're like, well, this could happen or this could happen. But it seems to me that in order for me to fulfill my duty as a criminal defense attorney, I need the client to be able to hear that from you or someone in your position that, well, it may not be clear, here are the possible choices as to what could happen.
Exactly. And, also to be clear, again, depending on what that crime is, going to me as an immigration attorney to lay out the options for your client might not be constitutionally mandated by Padilla, depending on what that crime is. But at minimum, there's the obligation to say, hey, this is a crime, this is conduct before, this is conduct from before you were naturalized. There could be an immigration consequence.
And what's interesting about what you just said made me think is that you don't know if it's a Padilla situation until you go to an immigration attorney, unless you have the knowledge of an immigration attorney. Meaning, I don't know if it's a clear-cut answer. I can tell you, looking at the statutes and the immigration side of things, there's nothing clear-cut. So I'm constantly in that situation, whether there's a, quote, clear answer or not, of having to go to an immigration attorney. It seems like almost in every instance.
Well, I think my sense of the Padilla opinion is that, what they're talking about is that within the Immigration and Nationality Act, there are some offenses that are, categories of offenses that are really clearly laid out. For example, it discusses any type of drug offense other than possession of 30 grams or less of marijuana. And so in Padilla, they talk about that as, okay, this crime fell within that. It was more than 30 grams. This is a clear deportation consequence. Other crimes, though, take more analysis. Other crimes, you have, very complicated immigration analysis as to whether it's removable or not. And so I think that idea of, it's a fuzzy line to be sure what's clear or not. And I would argue that more things fall on the side of being clear, just by virtue of, what attorneys should be doing as kind of due diligence for their legal research. But, the question is kind of, how do you come to that solution? And, how hard is it for you as a criminal defense attorney to figure out what the immigration solution is? And that would be kind of the argument behind whether it's clear or not.
Well, and I'm thinking through this, situations where you get a client, and maybe it looks easy to the extent there is such a thing, and then all of a sudden something like this pops up, and you've got to hire an immigration attorney, but immigration attorneys don't work for free. I mean, on the private world, and while you can try to call in a favor, the reality is you're going to have to part with some of your retainer in order to fulfill your duty. And I could see where that would be a struggle for some people. For anybody. I mean, everyone wants to keep the money that they've earned, but at the same time, it seems like it's almost it is a necessity here in these cases in order to fulfill, I guess, at a minimum, your ethical duty. It sounds like.
Yeah, I mean, even at a minimum legal duty.
Sure. And then the final one was the client is not a citizen or a lawful permanent resident, not in removal proceedings. The second DUI comes about. That's going to lead under this new decision to a presumption of not good moral character, I guess, of presumption of bad. And so it seems like that's not going to have an immediate impact right now, but at some point in the future, it sure may. So is that a consequence? Is it not a clear consequence? And how would you look at that?
So I think that this would fall in, all of these are so fact specific. Unfortunately, you can't really say like, oh, there's one category of cases that I'm going to warn about, another category I'm not. It's all really fact specific. I think that, what you have to do here is the minimum bar that's required in Padilla, which is warn that there may be some immigration consequences. And then depending on the facts, depending on kind of your read of the ethical rules, that may influence what more is legally required or what more is ethically required.
I see. And I agree with you. On the ethical side, I guess my opinion, and you and I are just talking opinions. I've had you on to talk about your note, not as an expert in ethics. So I just want to make that clear to everybody. But so we're just talking, but you've you've swam in this subject matter, and I wanted to get just kind of your thoughts, anecdotal thoughts about it. But it seems to me that even in this situation, I would owe it to my client under the ethical rules, if the client said to me staying in the country is important, to say, all right, I can't tell you for sure, but let me tell you that without this presumption, there are a few things that could happen. And I may not be able to predict out the future of his life or her life in every possible instance, but I think I could get broad enough to at least capture most of the most likely things that may happen. And I feel, in a way, like that's owed, it seems like, to the client. Is that your kind of anecdotal thoughts on that?
That's my take on it. My personal read of the ethical rules, and I encourage everyone to, go take a look at their state-specific ethical rules, which are binding. But my read on them is that, at the core of communication and trust and kind of objectives are at the core of any, attorney-client relationship. And so it's really important to talk with your clients and figure out, what do they want out of this criminal case? Are they concerned with the amount of time, of a sentence, or really are they concerned about coming out the other end unscathed from a immigration perspective? And really facilitating that process with them, working with an immigration attorney, doing research to, allow them to make educated decisions about their criminal case,
Right.
that will, mitigate possible collateral immigration consequences.
And it's interesting. And ultimately, that's what it's about, because when you go to plead guilty, or decide to go forward to a guilty plea or to trial, you have to make those decisions in a knowingly, voluntary, intelligent way. You got to know what it is you're doing and what the impact of what you're doing may be. And we've focused in the criminal realm on, you're giving up your right to testify if you plead guilty, your right to cross-examine witnesses against you, your right to appeal, all of the right to subpoena witnesses, etc. But I think it seems to be also important that people understand, all right, and these are some other things that are going to happen. It seems like that just makes sense to make that part of a defendant's understanding before they make a decision that could impact the rest of their life.
Exactly.
I'm going to look to you, Megan, for closing remarks. But before we do that, I didn't know if I wanted to give our audience, which in this case is also the person in charge of this CLE, is Laura, if Laura had any questions for you or for me.
I do. Sorry. I do. It's been a very interesting conversation. And I get scared because I think, forensic science has ethical issues in it. And it sounds like, in many ways, your guys' career, I mean, obviously you have ethical issues, but they're certainly not really cut and dry, especially on this subject, are they?
No, certainly not.
No.
So having had the fortune of working at the Oklahoma Indigent Defense System for a while, which is essentially the state public defender's office with the exception of Oklahoma City and Tulsa, and they have a public defender in those cities. But for overall the state, I know that when I worked with those lawyers, it was quite difficult for them. I mean, something that this is suggesting would be very difficult for those lawyers to implement, because by virtue of the statute that allows the Oklahoma Indigent Defense to function, right, the lawyers are not able to give counsel on anything except the case that the indigent client has been appointed to the state defender.
Yeah, I mean, there are certainly practical difficulties, especially when you're talking about, underfunded, overwhelmed public defenders' offices. But I think the point is that if you're representing a client, you're representing that client's interests. And so in order to be effectively representing that client, you need to figure out what his or her interests are. And so, although it might be difficult, and there again are certainly practical limitations, at the end of the day, if an attorney doesn't know an answer, we can't just say, oh, I don't know. Typically the response is, I'm going to look into that. And so I think it points at, the importance of kind of incorporating some immigration, law knowledge into criminal defense broadly, or, more collaboration between immigration attorneys and criminal defense attorneys.
So maybe more immigration legal education, as well as possibly these agencies being mandated to have an immigration lawyer on staff.
Absolutely. And, all of this is just my opinion, but I think it kind of goes hand in hand with holistic criminal defense.
That's a great point. I think I was thinking about it as you were talking about that, Megan and Laura, that the idea of a lot of what I do in the criminal defense world is presenting this person as who he or she is, which is a whole, full person, not a number, not someone sitting in a cage, but a real breathing person with families and needs and wants and things like that. And I think sometimes maybe we are subject to forget ourselves that in presenting that, we need to also realize that and act upon that in our relationship with the client. In this case, as Megan's talked about, of what are your goals, what are your desires? So we're treating, if you will, the whole person and not just one kind of condition, if you will, of their situation.
Well, and I had another question. This didn't come up, but as far as the communication prong that you both spoke of and detailed, how much communication, and I guess, Strickland, if you do a little bit, was that enough? And usually it is, if, the way that the courts look at it, if a little bit is done, was that enough? And maybe it, whatever, like you said, I'm a scientist, but doesn't communication a big part of this? I would think. In the Padillo case, he was from Honduras. I would think being able to communicate and have a translator would be very much a part of the process of knowing your client's desires. And if you choose to avoid a translator in the communication with your client, would that not be an ineffective?
I don't know per se, but my sense is that, and this isn't just relating to immigration, the immigration consequences of conviction, but as an attorney, you have to be able to talk with your client. And so if your client speaks another language, whether it's criminal law, civil law, any, area of the law, you need an interpreter if your client speaks another language that you don't speak, because otherwise you can't, even beyond not being able to establish, a true, like a relationship or kind of a foundation of trust there, you won't be able to figure out what your client actually wants to do in a case, or what his goals or objectives are.
Well, and I bring that up because, if you have to hire an interpreter and you have a limited amount of time to discuss things with your client on a criminal case, you are discussing the case. You're not necessarily discussing the foreseeable outcome and how it affects the immigration status, right? So I think that you would almost have to knowingly add extra time to be able to develop, because from what I'm hearing, again, I'm just a scientist, but from what I'm hearing is that you're going an additional step with the client, right? It's not just this criminal case, and you go over with your client the possible outcomes of sentencing, but then it's beyond that.
Yeah, it's one of the things you bring up is it comes down to, unfortunately, in our system, is that money brings you that knowledge, and it shouldn't have to. Or an attorney has to be willing to subsidize that. Because if you're going to do it and do it right, it's going to take that time that you're talking about, Laura. And that's the critical part here. And so then you've got overwhelmed public defenders who don't have enough time just on the criminal side of things. And now you're going to put an additional burden on them to become much more knowledgeable about their lives, the defendants' lives. In some cases, they're going to be moved quickly versus much longer cases, and it becomes just overwhelming burden. And I think that's the underlying problem of our system. Maybe is that it requires money to get the type of advice generally that you're talking about.
I think that it's, you kind of break it down. Like, it seems really overwhelming, but what it comes down to is, asking as a foundational matter, where were you born? What are you interested in this case? It doesn't have to be a long and drawn out conversation to kind of figure out those objectives. Ideally everyone would have time and you could, but I think there are, it's just kind of engaging in that conversation, and I think the resource problems are real and it's difficult. But I think that, the practice of law and the ethics that guide it are, we can't create our ethical guidelines based on kind of the amount of money it does to do something.
Right.
And so it's kind of a separate question, it's what do we have to do? What is this minimum, what's the minimum legal requirement? And then where should I actually be practicing or doing ethically? And then that's a separate question from, is there money to do this? And the idea, I think kind of my hope, at least what I posit in, my hope in what I posit in my note is that, if we have attorneys starting to do this, if we, see more holistic forms of representation, if, we incorporate more explicit comments about the requirements of it, that you have the requirements on what you need to advise your non-citizen clients of, eventually the structures will follow that.
Mm.
In the Padilla, one last question. In the Padilla case, what was there any with the ineffective assistance of counsel claim? Did the original trial lawyer that pled Padilla, was there any sanctions against that lawyer?
Mm.
I actually don't know.
I don't know. Yeah, that's a great question. I don't know the answer to that, but ultimately, yeah, that's what we'd face by violating our ethical duties.
But I think it's also worth noting that, part of the reason that, in that case, it would be for violating the legal duty. But, part of the reason that the ethical obligations are so important is because legally it's really difficult to raise an ineffective assistance of counsel claim. So typically that has to be raised, within 1 year while you're incarcerated. It's often a habeas petition. And so just practically speaking, it's really difficult for clients to do that. And so by kind of creating the ethical obligations where instead of trying to fix it from the back end, you have attorneys providing the advice from the front end, you can kind of sidestep that issue.
That's a great point. Megan, thanks for agreeing, by the way, to help, for being here today. And Laura, thank you for asking me to be a part of this. This has really been fun.
Well, I thank you both very, very much. I thank the viewers for tuning into another episode of Credits Without Contact. I hope everybody is staying safe out there and washing their hands very well. Sing happy birthday or sing We Are the Champions. And get yourself in that mode that you guys are the champions. You champion for all your clients. And with this talk today with Megan and David, there's going to be even more championing being done. And I appreciate both David and Megan for coming on and speaking to us on Credits Without Contact. And I thank the NACDL for putting this out there. And I thank the viewers, and I just wanted to tell everybody to stay safe and be careful.